known as the bail bill of 2024. Oh my goodness, you found a comfortable chair. Wow.
The only one in the building.
Yeah, they're not allowed here.
I don't know, I hear those stools that they just sit on are very comfortable.
I know. We used to have all of those chairs somehow. They let the store come in here and they just took all our chairs. So Ben, are you there?
I'm here, Senator Sears.
Okay, good. If you would lead us off, and this is Tuesday, February 13th, 2024. We're taking up a S-195, which is a bill dealing with bail. I'll call it bail reform, but I'm not sure it's reform as much as fixing some of the things that may be broken in our bail system. So with that, I'm going to turn it over to you, Ben, to kind of go through. I explained that you had some illnesses in the family and that prohibited you from being able to get things done as quickly as you would have liked, which is understandable. So what we have in front of us is a quick draft that most people haven't seen yet. So if you want to just kind of go over the highlights of it, it'd be helpful.
Yeah, thank you, Senator Sears. For the record, Ben Novogrodsky from the Office of Legislative Counsel. I appreciate your generosity in allowing me to testify remotely, and I will not be on screen today. Nobody wants to see me at the moment. But I'm not sure if the version that's in front of you at the moment is actually the updated version. I was going to ask if Ben could allow me to share my screen, and I would just go through it with you, and then
Okay, please do.
And for the portions that have not been completed yet, I would just give sort of a general overview of what is intended to be drafted, and we'll answer any questions that the committee has as a result.
And you're all good to share your screen.
Okay, great, thank you. Okay, if everybody can see my screen. So before us is the S-195 starting at the top, but the portions that have been changed from the last version that was released concern section 7554. You'll see that some highlighted portions is that there's now a reference to an Office of Pretrial Supervision. This is something that has yet to be drafted into the bill, but is essentially what it will be, or how it will be drafted, is excuse me, an entity under the auspices of the Department of Corrections with 6 regional pretrial supervisors that would essentially be responsible for creating a report either before or at arraignment for defendants, and recommending any conditions of release that may be needed based on an interview of the defendant or any other information that's readily available. This is largely going to be, the idea at least, is that it's modeled off of the federal program, which is in Title 18, Chapter 207 of the USCA. I've also been looking into Illinois' model a little bit. So that could potentially be another source for the committee to consider. But that, in a general sense, is when you see these references to the Office of Pretrial Supervision, this is what it should encapsulate. Any questions on that concept, at least?
No, we'll leave it to Judge Zone and Commissioner Demmel to comment on that, since they're most affected or impacted.
Yes, and that does remind me, so they would be under the auspices of the DOC, but would report to the court. So they would have sort of a dual, they would be under the supervision of DOC, but would have a role with the court as well. Scrolling down, you'll see here some additions in the conditions that may be imposed in subdivision F. So what this is a list of conditions that the court can impose, and there are two portions of this. In F, it's any right now imposing any condition found reasonably necessary to mitigate the risk of flight, including a condition requiring the defendant to return to custody after specified hours, and any recommended condition of the Office of Pretrial Supervision. So that would be added to qualify any other condition found reasonably necessary. Additionally, subdivision F or H is added to allow for the home detention program to be a new condition that's imposed. And then I revives the electronic monitoring program that was essentially tested out a few years ago, and now uses that as a condition that could be imposed. And you'll see farther down where in the statutes where these programs are either revised to permit it to be a condition of release or revived in its entirety. And then you'll see here subdivision J is place a defendant under the supervision of the Office of Pretrial Supervision. This would allow for people to be supervised, and this is really a consideration for practicality. Is that something the committee may want to consider, is whether everybody should be subject to supervision, or if there are just certain populations that should be, either those that are charged with felonies, which I believe is the case in Illinois, or those that may be repeat offenders or ones that already have conditions imposed that then violate them. So this would allow the court to make that determination.
And can you make a note of that somewhere for our committee discussion later on this morning?
Yes, I will.
Yeah, I think it's important that we frankly limit who would be under the supervision of these 6 officers, or whatever we call them.
Yes, I'll make a note of that.
I don't want to overburden with people that might just need to check in with the court once a month, or, you know. Okay, did you have a comment or question?
We're gonna have committee discussion
Yeah,
later.
that's the schedule for the end of the meeting. Go ahead, Ben.
Okay, great. I'll move on then. Here in subsection D, so this is in B2 where basically if the mitigation of risk of flight does not reasonably protect the public, these are the conditions that can be posed in addition. Here, it's imposed any other condition found reasonably necessary to protect the public, except that a physically restrictive condition may only be used in extraordinary circumstances. Actually, this whole clause may need to be struck because the home detention program might be something considered physically restrictive. So this is something that would probably have to be addressed in statute to permit it. And then
make a note of that for the committee discussion too, please.
And then you'll see here as well the addition of G, H, and I in the second set of conditions to be imposed. It mirrors the first set as well, so it gives the courts the ability to impose them for public protection factors that are insufficiently addressed from the risk of flight factors in the first analysis. Scrolling down, we will go to the home detention program. So section 3 of the bill amends 7554B, and the home detention program basically, which makes it usable for conditions of release, because right now it's only if someone is unable to meet bail after it's been imposed and they've been held for a period of 7 days. It does away with that requirement. So it would be now at the request of the court, the prosecutor, or any person charged with an offense other than a person held without bail under section 75, 53, and 53A. Those are the violent felony where evidence of guilt is great, and offenses with life imprisonment as a potential sentence. Those are exempted. They're now eligible for the home detention program. And you'll see here that so it may be reviewed by the court to determine whether the defendant is appropriate for home detention. The review shall be scheduled upon the court's receipt of a report from the department determining that the proposed residence is suitable. You'll see the next line is struck. It's not really applicable at this point in this context. And then at arraignment or after a hearing, the court may order that the defendant be released on the home detention program, provided that the court finds placing the defendant on home detention will reasonably mitigate the defendant's risk of flight. This change is made to be consistent with the definition that's used in the bail statutes now, and that the proposed residence is appropriate for home detention. So the procedure remains largely unchanged. It's just the eligibility and who can request it. And then you'll see here the addition of new subdivision E, which basically allows the department to either contract or issue grants to another state or its political subdivisions, a state agency or department, or a municipality or its political subdivisions, or a for-profit or nonprofit entity to assist in supporting the operation of it. So the department has the ability to get help in administering the program. And I believe that was reflected by the request from the committee at the last hearing on the bill.
Yeah, many other states do this, and I don't know if Massachusetts, for example, would be interested in contracting, but it's just a matter of physically monitoring the vendor with the ankle. Where does the ankle bracelet go, and then reporting it to sheriffs or whomever. So we need to work that out too. It reminds me, Ben, that we need to get copies of everything that's gonna cost money to the joint fiscal office to get a fiscal note.
Yeah, that is on my to-do list, Senator Sears. So
Thank you.
we're on the same page.
Okay, I like that.
And then as far as section 4, the violations of conditions of release, this is something I intended to revise that I have not been able to get to yet. And really, a couple things inform that. One, I finally had a chance to thoroughly vet the procedure and the cases necessary to inform a new mechanism for violations. I believe I spoke before how it was sort of an 11th hour bill proposal that we didn't have enough time to fully vet. Well, I've done that now. And I've also had conversations with the Department of State's attorneys and sheriffs. And I believe that they may be changing their, I don't want to say changing their position, and Tim Leaders Dumont can speak more to this, but basically I think that there's a hesitancy to repeal 7559, which is current VCR enforcement mechanism, and create a new one at the same time. He can elaborate a little bit more on the reasons why, but from a drafting perspective here, I do know that there's a potential conflict in subdivision 1 here with rule 3 of the Vermont Rules of Criminal Procedure. So this may need to be changed to either notwithstanding rule 3, which would then allow this to occur, or except as provided as rule 3, which would make this in addition to. And again, Tim Leaders Dumont would probably be able to speak better as to the reasons why. And then here, as far as under the hearing and then the standards of proof, this is a tricky part, to be quite honest with you. So normally you only need probable cause to arrest somebody. But in the context of a violation of conditions of release, the court has opined that you need more evidence than just probable cause. You really need a preponderance of the evidence standard. And this is really outlined well in State v. Gates. It's 201 VT 502 from 2016. And it talks that basically you need this higher standard because probable cause in and of itself would not be enough, because if you're in this realm of violations of conditions of release, anyone that would get a second crime and there was a condition imposed where one shall not commit a new crime, would take it out of the normal criminal process where probable cause would be enough. And it brings it into the violations of conditions of release and those new constitutional requirements that need to be considered by the court, where everybody is available as of right. There's due process. And so that's why there needs to be a higher standard here.
Senator Norris has a question or comment.
Good morning, Ben.
Morning,
I'm a little
sir.
confused with your explanation here. I would think it would be just in the reverse preponderance versus probable cause when we're looking at this. As far as you're stating that there has to be more than just probable cause for preponderance to come in.
Well, it needs to be a preponderance standard. It's not just probable cause. So the court needs to find that not just the offense was excuse me, let me just find the actual quote here. It says that basically that it's not that just probable cause is found, but you basically need to get enough evidence, preponderance of the standard of the evidence standard, that the crime was committed. So it's not just that you're alleged of committing it, but really that you actually did it. So that's the higher standard.
Okay, well, I'm sure the other witnesses will weigh in on this, but thank you.
And so, and again, so this would either need to be wholesale changed in this statute or proposed statute, or potentially put on pause given the state's attorneys and sheriff's recent comments to me. And so I wanted to highlight that for the committee. But if the committee does choose to go forward with that, with this new mechanism, in the disposition of violations, I do know that some other options like increased conditions of release rather than just jail time would be added as well. So that's all for the committee to consider. And then you'll see here in section 4, the addition of 13 VSA 7554F. This is reviving the electronic monitoring program. And you'll see here that it's the intent of the General Assembly that the electronic monitor program assist in ensuring a defendant's compliance with conditions of release, mitigating a defendant's risk of flight, or reasonably protecting the public. Then it gets into the program and the administration of the program, that the DOC establishes and manages the program for the purpose of supervising persons ordered to be under electronic monitoring as a condition of release, in addition to or in lieu of the imposition of bail pursuant to section 7554 of this title, or place on home detention pursuant to 7554B of this title. This language is almost identical to what it was before it was repealed, just with the addition of the home detention language. You'll see here that the program is intended to be part of an integrated pretrial supervision program and shall provide 24 hours a day, 7 days a week electronic monitoring with supervision and immediate response. The department may support the operation of the program through contracting or services with other entities similar to the home detention program. And then you'll see the procedure is that at the request of the court, the prosecutor, or the defendant, the court may determine whether a defendant is appropriate for electronic monitoring. At arraignment or after a hearing, the court may order that the defendant be placed under electronic monitoring, provided that the court finds that placing the defendant under electronic monitoring will assist in ensuring the defendant's compliance with conditions of release, mitigating the defendant's risk of flight, or reasonably protecting the public. In making such a determination, the court considers 3 items: the nature of the offense with which the defendant is charged, the defendant's prior convictions, history of violence, medical and mental health needs, history of supervision, risk of flight, and history of compliance with court orders, and any risk or undue burden to the other persons who reside at the proposed residence, risks to third parties, or risks to public safety that may result from the placement. That's a similar consideration to the home detention program as well. Basically, if they're going to be under monitoring, you want to make sure that who they're going to be with it's not going to endanger them. And then finally, DOC shall establish written policies and procedures manual for the program to be used by the department, any contractors or grantees that the department engages with to assist in operating the program, and the courts. Basically aim to provide a playbook, if you will, for everyone so that it could be used in a uniform manner. And then scrolling farther down, I believe those are actually all of the changes to the bail portions. Here, you'll see there was discussion about the use of firearm and that terminology in 18 VSA 4253. Given the concerns of the committee last time, now the definition of use of a firearm now just includes carrying a firearm while selling or trafficking a regulated drug. Before, there was questions over what possession meant, and if it could be, and in what context could someone be considered using a firearm. I believe a scenario that was given is if someone had a gun rack in their truck, and they had drugs in the truck but weren't necessarily engaged in trafficking or selling, would this essentially be an aggravating factor? And the answer is yes, based on the old version of the bill, it would have been. So what this aims to do is to narrow it so that someone has to actually be carrying a firearm while in the act of selling or trafficking a regulated drug. And there still may be a little bit of a debate over what carrying is, if it actually has to be on your person or within your reach. But that, in my view, is clearer than possession, where possession, if it's in your car at all, you can be deemed to possess it. So this makes it a more narrow circumstance, or at least aims to make it more narrow. And then you'll see here in subsection D, it's removed dispensing from this portion, so it would only be selling or trafficking, not essentially using or helping someone to use. And then you'll see here in what will be section 8, this is where the pretrial supervision statutes will be built out. As I
Ben, I'm gonna come back to you in a little while. Judge Zoney has a meeting at 10:30 with House Appropriations that I've told him to skip it, they're not important. He feels he should. So I'm gonna ask Judge Zoney to testify now. And unfortunately, we haven't finished the walkthrough, but we will.
Well, actually, we did. That's all of the changes so far.
Oh,
Good timing.
Good timing. Thank you, Ben. Hang in there.
Thank you.
Good morning.
Good morning, George.
Tom Zoney, Chief Superior Judge. So I've listened to what Ben was saying, and I've also gone through the version of 1.1, but I think given Ben's comments in the walkthrough, I think it might be helpful if I give a little bit of an explanation on some background. The issue that this 7554 and 7559 talk about is conditions of release and violations of conditions of release. If someone violates their conditions of release that are imposed under 7559, the court, the state's attorney can prosecute that as a contempt, and the court is required to go back and look at those original conditions and make changes if there's any that are appropriate. And the issue of repeated violations of conditions is something that is addressed in 13 VSA 7575. That's a separate statute. Ben was, I don't think he mentioned 7575, but he was talking about it when he mentioned the Gates case. And 7575 simply stated was the legislature's attempt to do what is somewhat looked at in this particular statute, and that is when there's repeated violations of conditions, what can we do? And in 7575, one of the provisions said that defendant bail can be revoked if they keep violating conditions of release. Well, the Vermont Supreme Court addressed that from a constitutional perspective in the case of Gates, which is the case Ben was referencing. And the court noted that except in very limited and special circumstances where the state's interest is legitimate and compelling, a court may not deny bail in the face of a constitutional right. The Constitution does not explicitly address what the state must show to authorize the court to revoke conditions of release. In 13 VSA 7575, the legislature attempted to fill the gap by establishing grounds for revocation by statute. And then it talks about that a case called State v. Save, where it addressed that statute. What it said was, the court found that revocation of conditions was not allowable under the constitutional provision in instances where conditions of release could not be denied in the first instance. That was the challenge that was made. The defendant was saying, you can't hold me without bail for revocation because you couldn't hold me initially. The Supreme Court rejected that and said, no, there are circumstances where you can. And what the court held was that revocation of conditions of release was allowable under the Vermont Constitution if the grounds were based on a compelling and legitimate state interest. The court concluded that a palpable threat to the judicial process, for example, to prevent a destruction of evidence or intimidation or endangerment of a witness, would constitute such an interest. It also found that the grounds for repeatedly violating conditions of release, in order to justify that constitutionally, there had to be a disruption of the prosecution, not just the repeated violations of conditions.
What does disruption of prosecution mean?
It could mean a witness says that someone violated conditions and they're supposed to go to trial perhaps, or a witness is not going to testify. The court has talked about a number of areas where it has to disrupt the prosecution. So for instance, if someone has a condition of release that says they can't go on the property of the town and the cemetery, and they keep going in the cemetery, that's probably not going to have any impact on the initial prosecution. But if they're doing something that affects the ability of the state to go forward in that prosecution, or the case to go forward, that would be a different circumstance.
State v. what?
This is State versus Gates, where the Supreme Court discusses this.
And the other one was state v.
Save, S-A-U-V-E, which is cited in the Gates case.
Okay.
And what the court did say was that you have to establish this by a preponderance of the evidence when there is that violation. And it has to be based on more than affidavits and sworn statements. Defendant must have a hearing with the opportunity to both hear and present direct testimony. The Supreme Court has addressed this, and I won't go through the numerous cases since then, but the Supreme Court has addressed additional cases since then. But that is the background, if you will, that this proposal 1.1 would have to be analyzed under. Is it constitutional to essentially revoke conditions in accordance with our current protections as interpreted by the Supreme Court? Now, I can't weigh in on that in terms of whether it is or not, except to note that it is something that obviously you'll hear testimony about. I'm sure there will be differing views on that.
I guess, from the public's point of view, the repeated violations of conditions of release make those conditions seem to be a joke. And that's the public perception. And we are given task here to try to deal with that, and at the same time do it in a manner that's likely follows the Vermont Constitution and the United States Constitution. So that's the conundrum that we face in trying to develop this bill. But if there's anything that gives a bad eye, it's 45 new crimes, and including violations of conditions of release, and the guy gets released again, and nothing changes. That's what's frustrating, I think, to everyone. I'm sure it's frustrating for the judge too.
It can be, absolutely.
It just worries me that we lose sight of that. Obviously, we have a tightrope to follow here, so I trust our legislative counsel in trying to deal with that, though that may answer Senator Norris's question about the preponderance of the evidence.
What the Supreme Court essentially says is that you can't just say, well, we have a new charge brought and that's enough to revoke conditions for repeated violations under 7575. The Supreme Court said you need more. You need to show that it probably occurred, not just probable cause. And again, you need live witnesses. And it seems as though the statute that has been, that I reviewed, that statute seems to be an attempt to implement a 7575 revocation, yet it also it's unclear whether it's a revocation or it's a punishment or it's a contempt. And I think that when you're looking at the structure, if the intent is, well, we want to review conditions to have new conditions that are going to be followed, that's one structure, and that's the current structure we have. And if someone violates conditions, it's not just, well, the court can review conditions. Current 7559 says the court shall review the initial conditions.
I think that, from my perspective anyway, I've used this example before, but I went to court on something completely unrelated. I don't even remember why I was there. It wasn't me, or somebody else. And there was, before the case that I was interested in, there was two drug dealers. And one of the conditions of release was not possess firearms. And the police had found them with numerous firearms, obviously violating the conditions. And rather than placing new conditions or some kind of sanction like electronic monitoring or home detention or whatever, they were released again. Please don't possess firearms again. Excuse me. The woman was released. The man was remanded, was put in jail. So that, was the outcome of that. But it was, I don't know what the outcome was of the jail, but it seemed like the court was saying, you shall not possess firearms, you're involved in the drug trade, and here we find you with more firearms. And it won't happen again, Your Honor.
You mentioned before, if you will, frustration.
Yeah.
Certainly, it is clear that when you impose a condition of release as a judge, you intend for it to be followed because that's critical to the public. You've determined that this is necessary for public safety. If someone violates it, you then need to evaluate it to decide, okay, what can we do next? But we on the bench are limited. If the Constitution says that this person, that bail can't be imposed because they're not a risk of flight, or the Constitution doesn't allow you to hold them, then you can't do it, even though you recognize that there might be 50 people in the courtroom who are saying, boy, this is just wrong. And we understand that. But the problem we run into is that sometimes people violate conditions, and the outcome is that we have to impose more conditions, which is why one of the things that we're trying to accomplish is shortening that time between apprehension and charge and the trial, because that's what's going to limit that.
Senator Sheen.
Thank you. So speaking about flight from prosecution, there was a point that I had flagged. I think it's on page 15 of 1.1, which is the version you have. And I'm pretty sure this originates out of the State versus Sauve case, but my understanding is that you can't lump together non-compliance with flight from prosecution. And you can't put it, if somebody's violating their conditions, you can't then say that because they're violating multiple conditions, they're a flight risk. Is that?
That's not accurate.
Okay.
Under State v. Brown, the Vermont Supreme Court concluded that the multiplication of charges and the mounting of additional charges may well indicate someone's not going to follow court orders, and that may indicate that they are a potential risk of non-appearance. It's an older case.
Gotcha.
And so I think that under that case, there is the potential for a judge, and I will tell you that I have ruled that way when someone has numerous violations. If I had concluded on the bench that I genuinely don't think they're going to show up, I think there's a risk of flight because of all the violations, I'm opposing bail. If I believe on all the factors, it's constitutionally warranted and appropriate. Now,
That was State versus
section-
Brown, you said?
State v. Brown, yes. And the section you just referenced does one other thing too. It ties in public safety as part of the definition of risk of flight. And keep in mind that the Vermont the Vermont Supreme Court has been very clear under State v. Pratt. It was one case where they talked about it, and many others, that the sole legitimate purpose of bail is to mitigate the risk of flight, not to provide for public safety. And so you have to, I would suggest, take a very close look at when you're going to start putting in public safety under risk of flight, defining them together.
States made in 1993. The constitutional amendment regarding bail had just passed. It was in effect that year. That was my first year in the Senate. I was a member of this committee, and I remember John Bloomer Sr., the Secretary's father, was chair of this committee. Several other members of the committee were all upset about how the court had interpreted the constitutionality just on that particular issue. And we've never overcome that, I think. But they felt strongly, believe me, I was a new freshman, never been on a Judiciary committee in my life, and I'm listening to the experts talk about what they thought they passed in the constitutional amendment and how the court interpreted what they passed. So you're taking me back to my early years, and we still haven't overcome that problem. Senator Bowski, so that's a historical perspective.
Yeah, so I have a question related to Senator Hashim's question. So if a judge looks at violations, do those have to be linked to a real risk of flight? So for example, if someone has a condition that they're not supposed to use drugs and they continue to use drugs, even though that's not related to leaving.
The thrust of repeated violations under Brown was that even if they're unrelated to the actual risk of flight, that if someone's not going to follow orders, there is a line a judge can intellectually draw between that violation, even on conditions that don't relate to flight, and the fact that someone might not follow the court order, because at its essence, the order saying show up for court and be here is an order that someone has to follow. So if they're not following orders to be in by curfew or not drink alcohol, there is an inferential step that can be taken to say, well, they might not follow this order either, and to show up. And so there is a risk of flight.
Now, if they had showed up for previous court dates, would that also be weighed in as
Absolutely.
like, yes, they're not following this order, but they are showing up?
That is exactly the type of dynamic, if you will, in the courtroom. And that happens, the state's going to say, okay, well, they're violating conditions, Your Honor, there should be bail. The defense may say, Judge, they've shown up every time. And then the court has to balance it under all the 75-54 factors and determine whether the court concludes there is a real risk of flight.
Is there any review of the conditions at any point? In other words, so the drunk driving case, condition is you shall not drive while drinking. It doesn't necessarily mean you can't go to a bar with a designated driver and have a few drinks, but if the condition says you shall not consume alcohol, is there any review of that?
There can be. If the state believes there may have been violations, or the state has information indicating that there should be some changes to those conditions, the state can file a request. If the defendant seeks to modify the conditions, he or she has a right to file a request. So the court does have the ability.
Conditions.
Yes.
Okay, thank you. Please go on. We've got a couple more minutes.
So I won't.
We'll have more discussion of this either at the end of this week or next.
There was the original draft to 1.1 had, was then page 5. There was a number of new factors for the judge to consider: the number of offenses, whether they're subject to release, things like that. And that is on page 5 of the original 1.1. I would, in my view, judges already consider those factors, so I take no issue with those factors being added. In other words, that's the type of information the judges will already consider. And to the extent adding it there highlights the legislative intent that that's something that really needs to be viewed and considered, that's something that certainly is not a negative. So it certainly is okay from our perspective. Again, when you're looking at this new structure of 7554E, I'll let the state's attorneys and defense talk about their views on the constitutionality of it, how things are set up. But I would again note that it seems as though this is trying to create a new process under Gates. It lowers the burden of proof from a beyond a reasonable doubt to a preponderance. And then it says that if someone's found to have violated, they get a jail sentence. There's a lot going on there, and it doesn't say whether it's prosecuted by information. It doesn't really outline the process, but it looks punitive. And if it's punitive, it has to have a constitutional basis. If it's deemed to be, well, it's contempt of court for not following conditions.
I thought we took that section out.
Okay, because it's
Ben
in one
helped me with that. There was a section of the bill that required 30-day,
Mhm.
10-day, 30-day, and forever. We're planning to take that out.
Okay.
Because, first of all, forever is quite a long time.
Yes,
The
there's,
intent
just, yeah, I do have that on my list to remove those and, you know, put in other alternatives if the committee still wishes to keep that structure.
I wonder if you could speak to the supervision in your final cut.
Sure. Well, the only other thing I would comment, if I could, on this new summary proceeding. If you put in a summary proceeding that says every time someone violates conditions, we're going to have to bring them right into court, we're going to not have the ability to address their underlying cases because we're going to be spending quite a bit of time scheduling emergency hearings on this. And so that's going to have a real, I think, a negative impact on the backlog. As far as the supervision component, the idea for DOC, under federal law, 18 VSA section 5134, I believe, is the section that sets forth how the federal system works with probation. And what it appears this statute tries to do is, in a much shorter version, come up with a pretrial monitoring situation that we have in the feds. The difference between, and by way of background, perhaps the largest component of my private practice before I became a judge was doing federal criminal defense. And so I dealt with this system frequently. The number of cases that the federal probation officers deal with is minimal. They don't have the arraignment system like we have, where you have arraignments scheduled or every day people are coming in. It's much more sporadic. And so there's a much better opportunity for them to be able to devote the resources to decide which cases, to prepare the reports, meet with people, and then monitor people. The numbers are just significantly less. The idea of having an entity to look out and monitor conditions of release is something that would seemingly assist in assuring that people are following conditions of release, because it fills a gap that does not currently exist. Whether DOC has the ability to deliver on getting reports done in all of the courts for all the defendants, well, I heard before the committee say that you might want to restrict on who has them done. Even with that, what you're going to be up against, I think, is a lot of numbers, and it's going to cause issues with timing and getting things done. And frankly, some of the people who we keep hearing about, the multiple offenders who keep having violations, probably would not be having cases that fit under whatever criteria you came up with initially, because the people who are getting the 35 or 40 seem to be people with, I'll call them lower end misdemeanors, as opposed to the more serious crimes, which there might be the ability to hold someone in any event under 7553 or 7553A.
That goes back to the Attorney General's recommendation that we have a special court for misdemeanors backlogged, and use retired judges to move those cases.
I don't know about a special court, but I can tell you that one of the things that we are doing right now is evaluating and coming up with plans to be scheduling special sessions of courts. For instance, in Rutland, the plan is going to be to take a number of misdemeanors and move them from the criminal building, the McCaffrey courthouse, up to the civil to have that done. We're going to be doing that in different areas to try to focus on getting these cases for that very reason. So functionally, that is something we're trying to work on.
Thank you, Judge. I don't want to hold you back.
Well, thank you.
10:30.
All right, and my final comments on, with the supervision. I understand the idea behind it. It did have value in the federal system because you were so limited in what you're dealing with. I don't know structurally how it would really work for the Department of Corrections to be able to deliver something that's meaningful for us.
Well, I think we're looking at limiting the number of people who come under the supervision to those who are not, who may or may not be on home detention, may or may not be on electronic monitoring, and those who have committed some serious crimes, not the misdemeanor shoplifter, who, and I realize that those are some of the ones with the 45 violations.
You just mentioned electronic monitoring, and I apologize, I didn't mention this. Absolutely support that. The broader type of monitoring that is available for courts, right now, we don't have the ability to order electronic monitoring outside of home detention. So to the extent that there would be the availability for electronic monitoring as a tool for judges to impose, absolutely would support that.
Sheriff Anderson has approached me, and I think probably others, about that. Quick question for Tanya.
Yeah, my question is if you're familiar with the Illinois system of pretrial monitoring, and if you think that would be a better fit, given that that is a state level system, not a federal system, and you may not be.
The first part.
Are you familiar with the Illinois system of pretrial monitoring, and if that would be a better fit, given that that is a state level monitoring system?
I'm very, very generally familiar with it, but I can assure you by 1 o'clock today, after my lunch hour, I'll be talking to the chief judge of one of the largest cities out there, hopefully, or one of the largest counties, to find out a lot more about it.
Great, well, I look forward to hearing from you after that.
My understanding is that in 3/4 of the counties of the state of Illinois, it's a state-run program. In the larger quarter of the counties, it's a county-run program. They work for the judiciary, I believe, and they answer directly to the courts.
Thank you.
But I'll find out.
I look forward to hearing from you.
Thank you.
Okay, we now have draft 1.2.
Thank you.
Thank you, Judge.
Thank you.
We'll now pick up with Commissioner Dummel of the Department of Corrections.
Apparently he's taller than
You
me.
seem to be a little lower than the judge.
Will you go up?
If you stand up, you can move it up. Right.
Oh, you have to be smarter than the chair.
That's
Tall
all.
order today. Good morning.
Good morning, good to see you.
Yeah, thank you very much. For the record, my name is Nick Dunlap. I'm the Commissioner of the Vermont Department of Corrections. So I think there's a lot to unpack here. I'd start, I guess, by saying in general, we think it's feasible for the department to be able to take on some of the work that you're asking about here. We, I think, are coming a little late to the game, but once we saw the initial drafts of S-195, we took on an effort within the department to study pretrial supervision. It's not something, as you know, that we've ever done before. And so we wanted to understand what are the models that are out there, what works, what doesn't, what does the research say about pretrial supervision. And so our team took on that work and came up with a memo, internal memo at this point, that details, here's what the evidence tells us, here's models that we've seen that work, here's what doesn't work, this should be avoided. And then we looked through the statutes as they're currently written to understand what authorities do we have right now, what would we need in order to execute this, and then we looked at the resources and what would it take. I believe we got research from the crime research group that suggests that about 8,000 individuals are on pretrial conditions of release. To give you some context, we currently have 4,000 individuals under supervision of the Department of Corrections right now. So that's twice the number of individuals. That includes everybody. So from your released on recognizance, small level misdemeanor, all the way to your violent felony. But that's a huge workload, as you can imagine, more than twice what we do right now. To give you some further context, the department has approximately 230 field staff that monitor those 4,000 people. And so just at first blush, the idea of taking on 8,000 individuals with 6 assigned staff doesn't feel workable for us. So how do we work through that? I think, Senator, you mentioned a couple of times the idea that we would put some criteria in place, that not everybody necessarily needs this level of supervision. Perhaps it's your serious felonies. Perhaps it's some quantifying of, you know, if you have 10 misdemeanors, maybe you do require heightened level of supervision. There's something going on that you're not complying with the rules as they've been laid out. And so I think if we had the opportunity, we could work with Ben on some of that to propose an eligibility framework that was acceptable by the state's attorneys and the courts, of course, but that would help us to bring the total number of folks down that were potentially being charged with supervising. I think what we've also found in the past is when discretion over our supervision.
I think these kids have found a captive audience in here, so. They were all smiling and.
Sorry, maybe.
Can you just finish that sentence?
Sure. What we've also found is when discretion is taken away from the department over the methodologies that we use to supervise, we tend to get worse outcomes. And so as much as we can and you're comfortable with, I'd advocate for you to give us, if you're going to give us the authority to supervise this population, also give us the discretion to supervise them using the instruments, the tools, the evidence-based approaches that we have in place so that we can get good outcomes.
Sounds like a good plan.
Yeah, and I'll pause there because there's some further detail on that, but I see.
Yeah, no, my question is about the 8,000 that are on pretrial release. Do you have a breakdown of who's been released on their own recognizance, who's been released with conditions, who's a repeat offender, which would help me get a sense of who are we actually talking to?
Me too. Unfortunately, no.
Okay.
And it's not our data. So we had to get it from the crime research group who gets it from the courts, but I don't think there's a lot of clean data.
What we need to find out to begin with is what types of crimes are we talking about? Maybe it's domestic violence.
Right.
Number 2 might be drug trafficking crimes. It might be other violent acts that we want to have supervised. But I'm sure some of those 8,000 are already on probation.
Right.
Or furlough or some other status, so they're already supposedly being supervised.
That's right. And for that population, however many individuals that are, we do have good data on the department itself. And so we're working to sift through that and come up with some good idea of who those folks are. But I think, you know, it's my prediction that a good percentage of the 8,000 are not currently within our supervision also. And so we're going to miss a good chunk of clarity.
I hear you, and I don't think we ever intended to have all 8,000 being supervised, but rather maybe a couple hundred.
Yeah. I mean, I think your intent is to manage, supervise folks who present a danger.
Also, letting the judge know who's in front of them.
Yep.
I think oftentimes the judge doesn't know who's in front of them. And they may know their name. I've actually had cases where I had a pair of twins one time, and each one would take the rap for something because they knew it was going to be a lower for them, and then they add up the.
Right.
And the judge had no idea which one, and I would, it's hard to tell the difference between the two. But be that as it may, I think there's frequently lack of information when somebody comes in and conditions of release are set.
Yeah. Yeah, and I think, and I hear very loud and clear, and I hear it in other spaces too, that there is a large concern around individuals who are racking up a substantial number of crimes, even if they're low-level crimes.
And one other group that and it doesn't take a lot of supervision. I have a relative who got herself in trouble in New Jersey, drug problem, and basically the court down there is monitoring her once a week. She's in Vermont.
Mm-hmm.
She has to call, she has to go to Rutland to get a urinalysis once a week. So that's the supervision. There's really other than a phone call, there's nothing on the,
Yeah.
other than that, and I don't know what happens if she fails. I mean, then I suppose they call her back, but
Yeah, so I think we would advocate for, and we're happy to help craft some kind of criteria on the front end of like who should go into this type of supervision program. And then we would manage that group, I think, throughout the state using our district offices. What we found in our research, though, is there's a fair bit of disparity in the evidence on what works and what doesn't with a pretrial population. There's actually some promising evidence that suggests kind of light touch supervision, maybe some of the stuff that you're describing, Senator, actually does help individuals with compliance of conditions. But conversely, heavy touch supervision, so you're kind of how we would supervise sex offender parolee, for example, does not help with compliance. And so we would want to continue to monitor that and measure out, which is why I think discretion is so important for us. We try to use evidence-based practices. We use instruments that have been tested throughout the country. Much of it is based on risk, either risk of violence, risk of flight, those types of issues, to get the right supervision type. And it may be tailored to an individual, maybe a little different for one individual versus another because of the needs that they present with. With that in mind, we, similar to Judge Zone's comments, would not look to the federal model as maybe being the best model, particularly for a state like Vermont where we have a unified system, we have a small population. There are states that are working on this and overhauling their supervision system. One of the states that recently went through that work is North Dakota. And so we've looked at the models that are available. We continue to work with our corrections agency partners around the country to find who's doing this and where is it working, where is it not working, so that we can present you with the best model that we think that we can. So however many people we get, even if it's in the hundreds, 6 individuals supervising that population is probably not enough. You'll remember that there are 14 criminal courts in the state of Vermont. We have 12 district offices around the state. And I think a better spot for us to be would have 1 pretrial supervision officer per district office. We think with 12, we could cover the entire state and the number of individuals we're talking about, particularly if we're moving towards a lighter touch supervision model. We probably would require 2 additional administrative staff because there will be administrative components to this that we think would need to be managed. And some of that is database type work. So through our offender management system, there'd be some retooling. We'd have to have somebody helping us connect with the court information systems as well, so we can get that type of information. So our proposal back to you would be, unfortunately, I think it's going to take a few more resources than originally contemplated, but we think that 1 pretrial supervision officer per district office probably could manage the workload.
Senator?
The 2 administrative support positions, is that 2 total or 2 per district office?
2 total.
Okay.
I got that question earlier this week, and I think the person fell out of their chair when they said 2, and they were like, that's 24 people.
Okay.
Sir.
Ben, can you look at North Dakota?
Yes, I can. And I can also speak with Commissioner Demmel and others at the department as well to work with them on what.
And we'll provide Ben, sorry, I don't mean to cut him off. We'll provide Ben with a copy of our memo so he has this structure.
That needs to be developed during 2024 and implemented a year later. I don't know that it can be done in a short amount of time. We have the pilot project in Bennington to have pretrial screening. And the state attorney reports it's not been successful. So I don't want to repeat those types of mistakes either. But it seems to me that the more we know about who's in front of a judge, the better the judge can make decisions about what the conditions should be or whether they should, be placed in an alternative setting.
The other bit of criteria I think we should contemplate, maybe right in the bill, is what happens if somebody violates a condition.
Well, that's the heart of the bill, really, is what do we do with those who continually violate conditions of release? What can we do? I described the gun situation, which I think is fairly dangerous. And doesn't necessarily protect the public. I don't know if there was a quality working there when the man went to jail and stayed out, but that's just my opinion in that case. Obviously, I didn't know all the details. I was just happened to be there at the time. It's amazing what you learn when you're in court. Periods.
Right.
You know, the administration came forward with part of this bill early on, particularly the sections dealing with what to do with the violation of conditions. We combined this with 195, which was Senator Collins' bill. So it's a hodgepodge, and we may have other bills going into it.
So then the last piece I would add is more on the statutory language piece. As you well know, currently the department has arrest powers over individuals under our supervision, under furlough and parole. But our interpretation of the law is that we would not currently have the arrest powers for individuals on pretrial supervision. And so if that was an expectation of us, language would need to be added.
No, I don't think it is. I think it would be referred to the court. The court can make its decision about it, you know, through law enforcement, regular law enforcement.
Okay.
What do you do now with home detention officers?
If somebody violates?
Yeah.
Well,
If they're not under supervision in another way.
I suppose it would go, I don't know that we've had anybody. Yeah, recently.
Yeah, the court makes the determination.
Court, yeah, I would assume that the plan here is the same. That you wouldn't, you would just report to the court that the person, you know, let's say it was electronic monitoring, the person wasn't where they're supposed to be, domestic violence case person, you know, is visiting the victim,
Yeah.
Whatever.
And then the only other question is, for somebody that we know is absconding or leaving, we know they left the state or whatever.
You know, one thing that's been successful and happened in my district many times is when probation and parole, law enforcement get together and check on sex offender compliance.
Mm-hmm.
And, you know, it's amazing the few numbers that come up. But one of the things we learned from the Michael J. case years ago was that when somebody who's a sex offender is out of compliance is when they're the most dangerous. So even if you check 100 and there's only 2 that are out of compliance, you've done something just by checking and identifying those 2 individuals.
So I think maybe the state's attorneys or the court is better positioned to speak to this, but I think there is, you know, an assessment by the department that if we start monitoring people pre-trial, the supervision model pre-trial, we likely will file more violations than are filed right now, which could add to the court backlog. It may also help cases resolve quickly, but I wanted to flag that just so folks are aware that we assess that once we start doing something, it will likely result in more activity in the courts, which could add to their backlog. But I think the state's attorneys or the courts could speak to what they believe will be the effect.
I was hoping it'd be the exact opposite. That more people would follow conditions of release who needed to follow conditions of release. I think sometimes we do things that we think we should do. Maybe are impossible for that person to do. But if the court orders somebody in to see and they don't, that's, you know, at least the court can give them a second bite of the apple or do whatever they need to do.
So if you're comfortable, we
I'm
will
very comfortable.
share our
I'm
message.
very comfortable with, holding off until we've had a chance to, I don't wanna say study it, because I wanna have it in motion, but to give you an extra year or whatever you need to put that type of program into place.
Yeah, I mean, certainly I think we have the areas of law that would need to be changed, highlighted, and we have proposals for how we would manage the program that we can provide to Ben, so he can incorporate that into your bill language. And then from there, happy to come back and talk through any of that and.
Hopefully we'll get to marking up the bill next week.
Okay.
And, get some closure.
So we'll get that over to Ben today.
Can I see you for 2 minutes on a different matter?
Yeah.
And we're gonna have Jay Green next. And if you can wait until I get back, it's only gonna take me a minute or two to speak to the commissioner. Committee don't go anywhere, but if you wanna.
Strict orders.
No, it's okay. Watch out what you say. Screwing it up.
Oh, they're screwing it up. Of course they are. All right, well, we'll fix it.
And I realize that was live. It's my second comment about the house.
We're muted.
Oh, we're muted. We can unmute now.
Yeah, we're all good.
They're gonna think I'm after them again. I haven't used the J word yet. Oh, and Jay's here, and he probably thinks I just met him. No, I didn't.
They.
Hey, I'm sorry. Excuse
Okay.
Sometimes I go old fashioned.
Thank you for the apology. I appreciate that. Jay Green, they, them pronouns. I'm with the Office of Racial Equity as the Policy and Research Analyst. Thank you for giving me the opportunity to testify today. I had marked up a copy of draft 1.1, so I'll give comments on draft 1.1 of this bill. Yeah, I think the main points that I wanted to communicate on behalf of the office is that we're very concerned at the speed at which this bill is being considered and put through without hearing from the Defender General's office or the ACLU of Vermont. We really would appreciate if the Racial Disparities Advisory Panel especially, we'd really appreciate if the committee would take the time to hear from Defender General's ACLU of Vermont and the Racial Disparities Advisory Panel on this bill. And that is because as I will lay out in the rest of my testimony, there are a number of provisions of this bill that have significant racial equity implications. And there are a number of provisions which, our
Let
office
me
had
put your
to,
mind at ease regarding the Defender General. He's not scheduled today, but will be
oh, great,
shortly. Yes.
Great,
We
great.
never do anything without his input or,
great. I'm glad to hear that you're planning to speak with
we
the
had
Defender
planned,
General on
we
this.
did not plan the other group, but.
Yeah, the racial disparities advisory panel, I think, would be a key group of stakeholders that need to be consulted on any major sweeping changes to criminal justice procedures in Vermont, because they have the expertise, and there are half of the racial disparities advisory panel is composed of community members with significant experience related to racial disparities in the criminal justice system. So yeah, it would be good to hear from the Racial Disparities Advisory Panel on this bill. Yeah, so I'll get into kind of our office's concerns with the bill. I'm looking at on page 2 of draft 1.1, lines 12 to 13. The $200 limit shall not apply to an offense committed by a defendant who has been released pending trial for another offense. I'm highlighting this because this sort of another offense language is very non-specific, and it doesn't differentiate the treatment of a defendant based on what the actual pretrial charges are, or what the pending trial, sorry, not pretrial charges, what the actual pending charges are. And this is concerning because we're concerned that this will increase the opportunities for pretrial incarceration, and that pretrial incarceration is likely to disproportionately impact Black and Latino defendants. That's based on the U.S. Commission on Civil Rights report on the civil rights implications of cash bail. Some really startling statistics from that report. They found that there were quote, there are stark racial and gender disparities with higher pretrial detention rates and financial conditions of release imposed on Black and Latinx individuals when compared with other demographic groups, and gender, where men are less likely than women to be granted non-financial release, for example, and face higher bail amounts. So men face higher bail amounts than women. More than 60%, according to the U.S. Commission on Civil Rights report, more than 60% of defendants are detained pretrial because they can't afford to post bail. Which, I understand that there have been a number of modifications to Vermont's bail laws that may make that slightly different here in Vermont, but it's concerning that we may be increasing the opportunities for people to be incarcerated because they cannot post bail.
Thank you. So and just to preface, this is more anecdotal, but one of the concerns I've heard about the $200 limit, and I'd be interested about your take on this, but one of the concerns that I've heard is that there are bail bondsmen who will not come out for a $200 bail because I think they only get 10%, so $20. And so as a result, even though, I'm getting the intentions and I support the intentions of having this limit, but if the unintended result is, folks not being able to use a bail bondsman to get out when the bail is $200, is there any thought on that, or is that something that you've heard of as well?
I haven't previously heard of that, but I have ethical concerns with the whole bail bond, the for-profit bail bond industry in general. So I would not use that as a
Whether we
reason.
have ethical
Right.
concerns or not, I mean, it's a reality.
Yeah,
They won't.
totally.
They won't, and so people, with little means, might be behind bars for $200, or somebody who had $2,000
I mean,
get out because the amount,
so the legislature could take actions to
the
remove
amount
the
would be $200, if my math is correct.
So the legislature could take a policy action to eliminate cash bail altogether,
could.
rather than relying on
But-
the bail bondsmen who won't come out for
I'm
more.
not sure that that's
Yeah,
realistic in this time.
sure, but I'm saying that there are other solutions besides relying on for-profit bail bondsmen.
The public is concerned, I'm concerned. And I listen to my constituents. They're concerned about the number of violations. They're not concerned about the person who commits a minor offense and is released on their own recognizance. They're concerned about people that are placed on conditions of release and continually violate those conditions, including new offenses. And that's, I mean, I respect what you're saying, but on the other hand, I think that's the times we live in, that's where the problem is, and that's what we're trying to address in this bill. Is those continued violations. Tanya?
I'm sure it comes as no surprise. I have a problem with that part of the bill and would also support
Well,
instead elimination
no,
of
it
cash
doesn't.
bail. But I wonder if that is an instance where if someone does have a violation, if they are immediately relegated to pretrial services, if that's one of those spaces where instead of imposing a higher bail threshold, which has all kinds of issues, we instead say that they would immediately be referred to pretrial service.
If you look at the reports that we had done, this is a little bit off of Jay's testimony, but I think it's critical to understand. The recommendations that led to 2018 and 2021 changes, in my mind, all required alternatives to incarceration for violations and conditions, and we never put in place the alternative programs. I don't blame only the legislature, I blame the administration and the courts as well. But if you don't have any alternatives, then it's either let the person commit 45 violations or put them in jail. If you had the alternative of home detention, monitoring, pretrial supervision, those types of alternatives, that might encourage somebody who's in front of the judge for the umpteenth time for violation of condition to actually go get the residential treatment they need for their substance misuse problem. Without that, you don't have, I mean, it's just a conveyor belt going through and nobody's supervising.
And Senator, I think I agree with you. And this bill stands up some of those alternatives that hadn't been before. And I think my opinion would be that we should stand up the alternatives and see if they work before we just wholesale undo work that was done in the past.
Understood. Go ahead, Jay. I'm sorry we interfered with your testimony, but that's.
Thank you. No, I appreciate the time and hearing the discussion.
But that's the conundrum that the committee is facing.
Yes. So I wanted to, if you don't mind, I'm going to go back to the comments that I had on draft 1.1 of the bill. So the next comment that I made on the bill was under, it's on page 5, B2, line 15 to 16. Judicial considerations in imposing conditions of release is subsection B, and then 2, there's a long list of what information the judicial officer considers, so the thing I wanted to highlight as especially racial equity concern here is the number of offenses with which the accused is charged. I'm concerned about the non-specific nature of the number of offenses, right? That doesn't speak to the nature of the offense, it's just the number of offenses. And that also comes back to a point that I made in House Judiciary a couple of weeks ago, which is that prosecutorial discretion does play a role in racial disparities in the criminal justice system. And if we have people of color systematically being given more, like a higher number of charges, then we're going to create racial disparities if we rely on the number of charges to consider as like considerations for this kind of legislation. So yeah, that is our office is very concerned with relying on just the number of offenses. I think the Defender General's office may want a chance to speak to the constitutionality of this particular section as well. Our office had a conversation with some of the Defender General's office yesterday, and they expressed concern about the constitutionality of some of the notion of expanding sort of what can be considered. I don't want to misquote them, and I'm not a lawyer by training, so I want to make sure not to introduce spurious evidence here. So I would let the Defender General's office speak to that when they have the opportunity. The Defender General's office also has concerns about the whole section 7554E violations of conditions of release and sort of the wholesale creation of this new process to address violations of conditions of release. So I will also defer to the Defender General's office on that. Sorry, that was on, yes, thank you.
Okay, I think we're.
Or no, sorry,
Wait,
that was
which
page,
page?
sorry, that was page 9 of 9 through,
Okay,
You're still on 1.1.
I'm still on draft
Okay.
1.1, yeah, correct.
I don't see any changes there. I'm missing.
So that was the introduction of,
You're on 1.2. You're on 1.
I'm on 1.2.
yeah, I'm on
On
1.
page 9, it starts with review of conditions, and it just changes
Jay's on
his and her to
1.1.
the person, his and her, he and her.
Yeah,
He
so
and she to the person, and then,
I'm looking at draft 1.1, so I think
Okay,
that my page
all right.
may be different.
yeah, that may, and I'm sorry for the, as I said earlier at the beginning, we're sorry for any confusion about which draft we're working from.
Totally fine, it happens all the time. So there was another specific subsection within that whole violations of conditions of release that I wanted to speak to on behalf of the office in terms of the racial equity concern. That was in draft 1.1, it's on page 12, lines 14 through 18. The court may revoke bail and hold a person without bail when the person violates a condition of release issued in a case in which the person could be held without bail or commits a new criminal offense while case is pending. So again, just kind of concerns over the kind of broad and undefined, like commits a new criminal offense while the case is pending. What kind of criminal offense are we talking about? Is this, are they truly endangering the public, or is this a criminal offense that is not actually endangering anyone but themselves? It's concerning.
Draft 1.1 is the bill, is combining 3 bills as they were introduced, and we've already made changes to, I realize it's confusing.
No, absolutely. Yeah. The next comment I wanted to make was on page 15 of draft 1.1, definitions, flight from prosecution. So that's page 15, lines 4 through 7. Flight from prosecution, the language that's been added is including noncompliance with court orders related to protecting the public, and failures to appear at court hearing. And my concern is with failures to appear at court hearings, because I feel like we're missing some data in this discussion. We're missing the stories of people about why they're failing to appear at court hearings. I'm concerned, for example, for people with substance use disorder who are having trouble managing their lives due to addiction. I'm concerned about people who can't find transportation or childcare on the date of their court hearing. This is, I'm just concerned with, and I'm speaking on behalf of our office is concerned with failures to appear at court hearings being treated the same as non-compliance with court orders related to protecting the public, because we're not drilling down into why people are not appearing at court hearings. I understand that you've seen cases where there's sort of defiance of court orders and people not appearing at court hearings because it's a safety, in a way that is creating a safety concern or a flight risk or whatever, but just failures to appear at court hearings is really, really broad and doesn't account for the barriers that people might face to coming into court in person, or via Zoom, because we know there are.
On the other side, on the other hand, failure to appear at court hearings without notifying the court or your attorney or whomever is kind of thumbing your nose at the court, isn't it? I mean, the court set a particular time. The court is there. Presumably the attorneys are there. And the defendant is not. That's part of the backlog that the courts are facing. So is that fair to the next person who's waiting to hear their case? I think, I understand there may be good reason for not attending. I don't think there's a good reason for not notifying either your attorney or the court that you, for whatever reason, I got stuck in a snowdrift, I've got childcare, I'm sick, whatever. If I'm on a jury waiting to be heard, if I'm on a jury, which I will be in July, and I am waiting there and the person doesn't show up, I'm fairly frustrated. I've done my public service and this person doesn't even have, that's my perspective. I understand there may be good reason, but I don't know how to deal with that any other way.
I mean, I hear you and I hear the frustration in your voice and in that experience, but what I'm concerned is that the statute is conflating non-compliance with court orders related to protecting the public and failures to appear at court hearing. That's all the same sentence, the same definition. So what that says to me is that the statute is equating those two things, and the severity of those two things and the resulting punishment that people should get for those two things. And in my mind, that does not seem equitable or fair or just.
That's reasonable.
Thank you. On the same page, under sentencing alternatives,
That's all been struck.
thank you. That's been struck. So this, the final, I'm trying to make sure that I don't take up too much of your time today, but these are the next couple of comments are the spaces where I think our office has the biggest racial equity concerns. So this is on draft 1.1, page 17, line 4 to 5. And I do note that some of these changes have, like, for example, so I highlighted use of a firearm includes carrying or possessing a firearm. I understand that possessing has been struck, so it's now just carrying a firearm. Last week I was watching the testimony on Proposal 1 that Sheriff Mark Anderson gave, and he mentioned the racial disparities that were created by treating crack cocaine possession just different from powder cocaine, right? This is another area where we are creating racial disparities through the definition of carrying a firearm because of the patterns in groups of people who tend to carry firearms versus other weapons. So recent CDC Youth Behavioral Risk Factors Surveillance Survey data suggests that youth of color, like Black and Hispanic, using their term Hispanic youth, are more likely to carry guns than white youth. So by putting in carrying a firearm, we're making the sentencing more severe for Black and Hispanic youth under the CDC's data. So, and I'm happy to provide the committee with a list of the data sources that I'm citing after this meeting. So,
it would be helpful to get the data, but I'll just comment that we can argue all day long, but when they're shooting people, I don't care what color, when they're firing the firearm, that's what's most concerning to me. And I had the case in Danby, the young man who was evidently put in a car in Pownell and driven up to Danby and shot twice or four or five times. I think he was 18 years old. It was either Hispanic or Black, I'm not sure. But the two white people that were driving the car, that occupied the trailer that he was living in, they had 3 charges against them. 2 of them were not found to have probable cause, but the one that, you know, charge of murder after the fact. I think if I looked at that racial disparity, it was the white people participating in the murder of a Hispanic kid.
Yeah, I wanted to go back to what you first said, which was that your concern was with people firing their weapons, and I don't see that carrying a firearm is the same thing as firing
Well,
or using the
There's
weapon.
been cases where the individual places a firearm on the coffee table. That certainly suggested that they're gonna use it if the person doesn't comply with their orders. So, yeah, it can be burned up, and I'm not disagreeing that it may be, but I am worried that if we want to use all other weapons, we can. I thought it was better to narrow it to firearms, but if you would prefer that it be any weapon.
I was not suggesting that we expand this to include all weapons. I would also note that the CDC data are based on surveys of youth in high school aged youth who are reporting carrying a weapon because they feel unsafe and they feel they need to carry a weapon for sorry, let me restate that. Some of the youth that are reporting carrying a weapon are carrying it because they feel unsafe and they feel they need to protect themselves by carrying a weapon. Some of them may be involved in, or intend to commit a crime with that weapon, but some of them are carrying a weapon because they feel psychologically that they feel unsafe in their environment. And a reason for feeling unsafe in your environment might be persistent discrimination and bullying based on your race or ethnicity, etc. So
This section,
we're catching a lot of people in this one definition and increasing their potential criminal penalties, and there are racial disparities in that. The other
so what do we
concern.
do? What do we do?
Yeah, I'm sorry, Senator.
No, what do we do? Seriously, what do we do if there's racial disparities, but people are dying and people are getting shot in our communities, and this behavior continues, and yet, what do we do?
I would raise the concern that a lot of these, this section, I was also going to comment on the conduct constituting the offense of using a firearm. While using a firearm, I note here, under that definition means just carrying, not even firing the firearm, but using a firearm while selling, dispensing, or trafficking. I know dispensing has been removed. Or trafficking a regulated drug shall be considered a violent act for the purposes of determining bail. This is the same kind of policy language that if you read, for example, the new Jim Crow by Michelle Alexandra, I'm sorry if I'm mispronouncing her last name, but this is the exact same kind of policy language that has led to the disproportionate incarceration rates that we see now among Black and Latino defendants versus white defendants. We know that people use drugs at approximately the same rates regardless of their race or ethnicity, but we see a history of higher sentencing and harsher punishment for Black and Latino defendants. And the reason for that are provisions like this sort of sentencing enhancements. And I apologize if I'm using the term sentencing enhancements incorrectly, but to me, as a non-lawyer, this kind of policy change that you're seeing in D is part of that war on drugs philosophy of we need to be tough on crime, we need to incarcerate people for longer, we need to impose higher punishments, and we're trying to undo those changes that led to mass incarceration. And this, to me, reads as if we are putting back into those same policies that led to mass incarceration. And yeah, I think our office's position would be to strike that provision entirely. And I think you're speaking to some real experiences that your constituents have had in terms of concerns over their safety, in terms of concerns over the use of firearms in crimes. But I'm saying that the policy response, this is going back to a policy response that created the mass incarceration crisis that we have today. and that specifically created racial disparities in the criminal and juvenile justice systems that we're trying to dismantle.
Senator Norris and then Senator Sheen.
Yeah, thanks, Jay. I guess I find some of these very concerning when you talk about groups of individuals who are in public and they may feel threatened or whatever else, so they're carrying firearms. And as you say, it may be members of the BIPOC community or whatever else. So if they're carrying the firearms, they're carrying with potentially an intent of using them, correct?
I would like to highlight your word there, potentially an intent, right? That is not the same as committing a crime. That is potentially an intent.
But they're carrying a firearm because they don't feel safe.
Possibly,
right?
Yeah.
And when you start talking about going back to mass incarceration or whatever else, I was watching on the news the other day where I'm such a center series is reacting to my constituents, and they don't feel safe in their communities presently. So we have to address their concerns. And I see yesterday, day before, in Newport, they had a group of individuals, imagine this, were actually out front of the courthouse, like Lives courthouse, protesting that they want tough on crime laws. They want us to react to that, whatever else. So those are the things that we're seeing. I understand your concerns, I certainly do, but we have to deal with the folks that we serve, and they're saying that what's working isn't working right now. Okay, so that's what we're trying to, and it may be a knee-jerk reaction. I'm not sure, Jane.
I would argue that what hasn't worked for the past 50 years is the war on drugs, tough on crime policies, and that if we look at the data, and I understand that your constituents have concerns, and I'm not denying that those feelings and those concerns are real. I'm saying that the policy response, on behalf of our office, I'm saying that the policy response should not be a return to war on drugs style tough on crime policies, because we already know that those policies have created the conditions we're trying to undo right now.
But we can agree that what's happening right now is not working.
I'm struggling to give you a firm answer of agree or disagree, because what's happening right now varies widely depending on what data sources you consume, what set of facts you accept or do not accept. I don't think we've come to a consensus on what's happening right now in order for me to say, yes, I agree, or no, I don't agree. Because I think what's happening right now is somewhat subjective depending on your point of view.
Thank you.
Thank you.
Senator Sheen had a question.
Thank you. I have a quick comment. Thank you for raising the new Jim Crow. I read that book when I was a trooper, and it was one of several things that caused me to end up working at a defense firm for 4 years. And your point is very well taken for on page 17, lines 4 through 6, regarding carrying the firearm and all the factors that you had described earlier. The area that I'm having a harder time grasping, though, is I think what we were just talking about regarding lines 9 through 11. I get the differences between carrying and versus using. And when I'm thinking of using, going back to the conversation earlier, I'm thinking of shooting a firearm at somebody else. And so I guess the rhetorical question that I have in my head regarding this particular line or paragraph is, at what point when firearms are being used against other people, can we say, okay, we have to consider a way to keep people safe and prevent these firearms from continuing to be used in an unsafe manner, which I think is in a different category than just carrying a firearm because you reasonably feel unsafe. So that's my general comment. Of course, if you want to respond, go for it. But that's what I'm thinking.
Yeah, I think that to me, it seems like there are existing charges that could be brought against someone for threatening someone else with a weapon. There are existing mechanisms for saying, that threatening someone with a weapon, brandishing a weapon is different from just having it on your possession, hidden, and the other person doesn't even know it's there, right? Like there's different shades of sort of behaviors and how threatening or unsafe they make the other person in the interaction feel. But just saying carrying doesn't encompass any of that nuance. If it's all right, I think I would like to, I know I'm taking up a lot of your time today, so I just wanted to point out, when we spoke with the Defender General's office, I'm not sure if this has been struck in draft 1.2, but I'm looking at page 18 of draft 1.1, line 16, a repeat offender shall not be accepted by the diversion program. The Defender General's office input was that this is directly contradictory to other.
We struck that.
Okay, great, yeah. And then my final comment was going to be that there's a request for a report about restorative justice referrals on page 22 to 23. And I just wanted to remind the committee that our office, and specifically the Division of Racial Justice Statistics within our office, I think we would like to be included in the data sharing provisions there, and in the stakeholders that need to be consulted on this report, since the Division of Racial Justice Statistics is tasked with being sort of the statewide clearinghouse of all of these data, and to analyze it for racial disparities in our criminal justice system.
I think that report was also struck, as we felt like most of the data was captured elsewhere.
Oh, okay. In that case, never mind.
Well, thank you, Jay, and I appreciate your testimony and your thoughts.
Thank you, yeah. Yeah, thank you very much, and if there are no other questions,
If you wanna, if after you see draft, whatever the new draft number will be, you're welcome to make comment on that next week. Let them know.
Thank you. And if you don't mind, if I could make one suggestion, I think that it would be really great to do a systematic study of violations of conditions release and get a better sense for, a better sense of the data of what conditions of release are being violated, why they're being violated. You know, this would likely involve interviewing people who have violated their conditions of release and getting an idea of why they did that. And I think this conversation would be a lot, and perhaps Crime Research Group of Vermont can provide some data with regards to like which conditions of release are being violated. I'm not sure how detailed the court data systems get on that, but I would really love to see the statewide data on which violations of conditions of release are being violated and why.
Any other comments? Okay, thank you.
Thank you very much.
Tim, thank you for waiting.
We'll do the dance here with the chords. Should we stretch?
I just wanted to catch Jay before they left.
Oh,
But it looks like you're sitting,
Yeah.
okay.
Tim Leaders, Vermont, the Department of State's Attorneys and Sheriffs. And, sorry.
Which draft are you gonna be on, Tim?
I actually did review 1.1 as well, but I understand the parts that you've taken out, like the diversion piece that they were just speaking about, the repeat offender piece. We had similar concerns about individual circumstances leading to the individual analysis required for the restorative referral process. So we shared, I think, some of the concerns on that, and also, I think, the portion about the report, I understand you took out as well. So I did submit some selected comments just for the purposes of having it on the website. I'm happy to walk through some of those, but also there was a couple of things that came up during testimony. So at any point, stop me. I can always come back. I'm super convenient and all that. So do you want me to walk through some of the comments? That'd be helpful. Yeah. Okay. So on the first page of draft 1.1, and I think it remained in the next iteration, I wanted to walk through, there's a deletion of except as provided in subdivision 2 of this subsection. This has to do with the $200. So on page 1, you've deleted, the draft deletes except as provided in subdivision 2.
Which line you on?
Line 20 on page 1 of draft.
Thank you.
And then
You
it's
have a copy with Tim's comments on the side.
Mm-hmm. Oh,
very high tech.
Very high tech. It's in yellow.
All right, another copy. There we go.
Yeah, it's in yellow on the right. But we'd be opposed to the deletion of that section for a couple of reasons. And if you just sort of read the next section, what that does is it says, except as provided by subdivision 2. Subdivision 2 creates the $200 limit. And so if you were to read it in its entirety, what it now says is no bail may be imposed at the initial appearance of a person charged with a misdemeanor if the person was cited for the offense in accordance with Rule 3. So breaking that down into its parts, it means that no bail can be imposed on an individual who's been cited. That's what that does. And the subdivision 2 would apply for individuals, only individuals who have been arrested under Rule 3. So if you've been cited, which is at the discretion of a law enforcement officer in interaction in the community under Rule 3, if you've just been cited by Trooper Hashim, then no bail could be imposed. But if you've been arrested by Trooper Hashim, then bail could be imposed under subdivision 2. That's the way I was reading it.
Well, the way I read it, I mean, so you're cited, coming into court in 3 weeks. You've been out for 3 weeks with no conditions, correct?
Or there could be conditions that were put in place by the court during the interim, between the citation.
But you're released with no condition. Because you're cited. That's how I read it, and that's why.
And what I'm saying is in each Rule 3 analysis out in the community, because of the discretion of an officer, as we know from your hospital bill last year, individuals can be cited in one circumstance and arrested in another circumstance, depending on what's going on. And what this does is it treats individuals who are cited versus arrested differently. And so those who have been arrested at any point in their interaction relating to that case could have bail imposed. Those who have been cited at any point during their case could not have bail imposed. And if that's the way I'm reading it, it probably would get hashed out in some form of litigation, because I do think it could be argued as you've suggested. It would depend. And I just wanted to flag that we're opposed to that, because we do think that the except as provided by language is really helpful, because it allows for the imposition of bail to mitigate the risk of flight from prosecution as to anyone, depending on their circumstances. And it doesn't treat individuals differently as if they're cited or arrested.
Okay.
And sorry if that's convoluted, but
No.
it creates some issues that we
Not
would see.
convoluted.
Senator
Bahowski.
Yeah,
yeah.
I just have a quick clarifying question, because I sometimes feel like I'm at a disadvantage because I am in fact not an attorney.
Or an advantage because you're not clouded by whatever we're doing in our brains. We're not.
Yes, I think it just depends on where I'm sitting. At this moment, I'm feeling a disadvantage. If someone is given a citation, that is for a civil offense, yes?
No. It could be for a criminal offense.
Okay.
Yeah. So Rule 3 allows for an individual, for example, for a non-witness misdemeanor, you could be arrested for violating a condition of release relating to a curfew under Rule 3. You could be arrested, taken away from wherever the scene that the alleged offense took place. You could be, basically they could process you, and as soon as the conditions of the circumstance fall away, then the citation has to issue under Rule 3, but you can be arrested. On the other hand, an officer could use their discretion to say, I'm just going to cite you into court 6 weeks from now. No arrest takes place, here's the citation. And so you still have a criminal charge that may be coming. The prosecutor still has to review the affidavit, but the person could be treated very differently depending on the circumstances. And what this does is it says if you've been arrested, you can have bail imposed on you during the pendency of your case. And if you've been cited because of that discretionary point by law enforcement at the onset, if you've been cited, no bail can be imposed on that individual. And I think that's not likely what you're intending, but maybe it is.
So, I mean, how often do you see that happening when a cite is being handed out versus, the handcuffs being put on? Because, well, yeah, how often do you see that as an issue?
It is hard to summarize because it's so specific. I mean, I used you as an example, Senator, but the example that is kind of most mundane is an individual refuses to say who they are. So, I'm pulled over, I don't give you my driver's license, I'm not giving you my name. That's how you get arrested under Rule 3, because you're not cooperating with the basics of the investigation. Who is this person that I'm interacting with? So you can be detained so they can do a little investigation into who you are. In that circumstance, you may be arrested. If I say, my name is Tim Leaders Dumont, I live here, etc., much more likely to result in a citation if there's not other things going on, because I've identified. Rule 3 provides if you don't provide your identity, it's one of the bases upon which you could be arrested without a warrant. So it's very fact specific. It's hard to sort of summarize. It would depend on circumstances.
Senator Wells.
I just have another clarifying question on language. So you mentioned that if someone didn't cooperate, they could be detained. That's not the same as being arrested, correct?
Most arrests involve some, even if it's very brief, even if it's just being taken to the cruiser or away from the scene, that's a brief detention.
But you could be detained without ultimately being arrested. Those are not synonymous terms.
Yes,
Okay.
and you may not be free to go, which then implicates your Miranda rights, but yes.
Okay, I just wanted to, because it seemed like you were using those words a little interchangeably, so I just want to be clear that my read is right and they're not.
I want to try to move on from this issue, although you've seen the resistance.
Yeah, I just want to flag, I think it could have very broad implications to daily practice.
I appreciate it.
Yeah. Just to be clear, on page 2, we're very much in favor of the suggested language. The $200 limit shall not apply to an offense committed by a defendant who has been released pending trial for another offense. This just gives the judge the option to say, if you're out in the community and on the first instance, you've had the $200 benefit of having a $200 cap. On the second instance, the judge may say, you've violated conditions, you engaged in alleged repeated conduct, then the judge can say that the $200 limit doesn't apply. It's sort of a graduated sanction type of idea, but in the bail context. So we are in favor of that language. And that's, I don't believe you talked about just striking it in the second draft, so I think it's still in there.
Don't want to open up a can of worms on this, but I also kind of do. Regarding bail bondsmen, it's in a point that we were talking about earlier. I mean, I've always thought the system is a little strange to have this for-profit mechanism that is used to, get someone bailed. Do you have any thoughts on how we can shift away from that so that we're not encountering this issue, what I think was an unintended consequence of someone not being able to get a bail bondsman out because the bail bondsman isn't going to make enough money on a $200 bail limit?
One of the issues with the $200 limit, and I don't know if you want to ask yours first.
No,
okay. One of the issues with the $200 limit is that it's a rote non-analysis that's taking place, right? $200 might mean very little to one person, it might be a lot for another person in terms of the $200 presumption for expungable misdemeanors. Therefore, as you've said, with a bail bonds person, it's not worth their time potentially to go out and help that person. If it were more an individualized analysis, that $200 is the limit. So a judge could impose $50 if they thought that was something that was more reasonable. It's just the limit. So not every instance of the $200 is it going to be imposed. Often you see like a $100 arrest warrant for someone failing to appear. I've seen a $50 arrest warrant, et cetera. But it does bring up the issue of this reverse incentive, essentially, that you've talked about. I don't know how to address that when we're creating limits and misdemeanor as opposed to just having an individualized analysis. But it's a very valid point. I haven't personally seen that too much on my end, but I've heard of it from a couple of folks, including yourself. Yeah.
Thank you.
Yeah.
So my understanding under the Vermont Constitution is bail may only be used in order to ensure someone returns to court. The mechanism you are describing as a sanction, wouldn't that be unconstitutional?
I was describing it as an analogy relating to other instances in statute where we use graduated pieces, but it's the only purpose of bail is to ensure someone's engagement with prosecution, as you said. Yeah.
Yeah, I'm confused as to how allowing for someone to be given higher bail because they say had a drug screen that came back.
It just removes, what you're trying to do is remove the cap so there can be more of an individualized analysis. Sometimes what we've seen, at least that's the way I'm reading it. I wouldn't describe it, as you said, as a sanction was the wrong word, but essentially the only purpose of bail in Vermont is to ensure the engagement with the prosecution and to mitigate any risk that they are not going to show. That's how bail is used. The $200 limit for all expungable misdemeanors, regardless of what's happening, leads to some interesting scenarios. For example, a judge saying, okay, the person has 10 pending counts that are coming in overnight, 10 times 200, right? Sometimes that's what people do, instead of a more individualized approach, which could be, I see this person has 10, I'm going to impose $1,000 because the $200 the last time was not enough. That's sort of the scenario in the field that I'm talking about. But hopefully that was I'll try to steam through because I know that you've got limited time. Page 3, I'm actually not going to dwell on because the definitional change of risk of flight from prosecution is essentially what I would recommend putting in this section as well if you wanted to have it be clear so that a judge, when they're looking at the imposition of bail, this is page 3. Right now there's really no changes to this in your draft. If you look at the term "if the judicial officer," which is line 12, right before that, there's the factors, the seriousness of the offense, the number of offenses, etc. We had recommended that after a person is charged, that section right there, that we would recommend you also put in the language about non-compliance with court orders and failures to appear, so that the judge, when they're going through this, or practitioners, when they're going through this, know that those are two things you should definitely be looking at. In practice, judges very, very much look at failures to appear. It's the number one question you get about whether or not to impose bail. And as noted in State v. Brown, non-compliance with court orders are already a part of that analysis, but putting it in the statute helps with clarity. So we would recommend considering putting in there, but when you're changing the definition.
What happens when somebody doesn't appear?
Let's say we're
in court.
Yep, we're at arraignment morning or something.
Somebody's notified you they're not coming. They don't have any. What happens?
So let's say they're being arraigned for DUI and they don't show up. The judge, it's called a no-show in sort of the common parlance, but the judge leaves the no-shows to the end of the people who are there. So we address those first to kind of circle back. Sometimes the defense attorney is there and their client is not there. Other times, if they're pro se, for example, the judge could consider a bunch of things. They could do a judicial summons, which is a no cash summons. They could do essentially a cite and release, which is another no cash piece. If they're put up again, cite them again. Just try citing them again. They could do cash bail of under, often you see a $100 arrest warrant for lack of appearance. So the no-show sometimes results in an arrest warrant with cash bail attached to it. Sometimes it doesn't. Often when they do show up in court, we immediately strike the cash bail when it's for a low amount. The judge will strike that. But the judge is exercising their discretion to try to get the person re-engaged. Sometimes you get a scenario where the defense attorney says, well, he's got another arraignment next week. Maybe he's confused, as you pointed out, some of the pieces that Jay pointed out as well. In that case, sometimes the parties agree to say, okay, all their cases are coming in next Thursday. It's very fact specific, but it sometimes results in a cash bail warrant. Does that answer your question?
Yeah.
Yeah.
Senator Bowles.
I'm just wondering if you're aware of the racial disparity seen within the Vermont cash bail system and the Crime Research Group's information on that and how that does not appear to be applied in an equitable manner, the sort of discretion you're talking about.
I'm sorry, I'm not quite understanding the question.
So you're advocating for this level of discretion around cash bail?
Judicial discretion.
Yes,
Judges
and
impose
I'm
cash bail.
wondering if you're aware within our current system of the racial inequity within the cash bail system because of discretion, like what you're advocating for more of.
I would leave it to Judge Zoney to talk about judicial discretion. But if you're talking about, because we sometimes ask for bail, but it's the judiciary that imposes bail conditions, et cetera. So I don't know that I'm the right entity to speak to the judicial exercise of discretion. Certainly it's a separation of powers conversation, just like our ability to charge or not, or to refer to diversion, et cetera. But I think there's national data that Jay spoke to about, the history in this country of racial disparities. So
We have Vermont data as well, and I'm happy to share it with you that shows that there is inequity on racial lines in our current system. And what I'm worried about is the expansion of that exacerbates that.
And what would the expansion be? The $200 piece?
Lifting caps, allowing for more discretion, like
The $200 limit was not in effect in prior times, and I don't know if there's been a test as to whether things have gotten better or worse from that perspective on that, but I'm happy to certainly love to chat with you further about that. I was on the Sentencing Commission all fall and summer talking about some of these topics, related topics, and certainly very familiar with Crime Research Group, but I'm happy to look at whatever you send over.
Yeah, I'll try to find it. It's in my email somewhere.
Thank you. The piece about conditions of release that were discussed, we don't really take a position on that. That's on page 5, about basically allowing judges more factors to consider when they're doing conditions of release. Page 5, starting on line 15. We don't see a problem with judges imposing conditions of release. So I think it's borderline superfluous language, but I understand. We don't take a position on it. We wouldn't really see that this would impact practice particularly either way. I wanted to jump to a topic just before, so we don't run out of time, about the question of 7559. That's on page 13 of draft 1.1. That's the current statute that we use to charge violations of conditions of release. And I'm saying this because in talking with lots of folks in our department, oh, sorry, Senator,
Not a problem.
there's probably 72 different opinions in some ways about some of this. So I'm not reflecting a state's attorney position when I say this, but if you were to put into effect that summary proceeding that you contemplated here to enforce VCRs, you would want to make sure it worked before repealing the current mechanism to have violations of conditions of release, if that makes sense. So before repealing 7559, which allows for the current filings of conditions of release in Vermont, and as of January 9th, there were 4,605 pending counts of conditions of release in the state. Before repealing that, you'd want to make sure that your replacement system was working, you had worked out any kinks, et cetera, and we'd be happy to continue that conversation about what 7554E looks like, the summary proceeding that with the different detention levels, et cetera, that you were talking about. I know you're looking at changing that, so maybe when that new draft comes out, we could circle back. And, we have a couple deputies that are pretty engaged on this topic, and we'd be happy to keep working with you on that. But the point being, before you repeal something that's existing law, make sure the replacement mechanism is effective and working. If that makes sense. Does that make sense? Okay. And then, moving on to page 15, the flight from prosecution definition. So to be clear, this isn't about any punitive measures or sanctions, et cetera. This is about pre-trial, the proper analysis for flight from prosecution. As noted by Judge Zone, the judge can already take into account the non-compliance with court orders, what's happening in the community. It's something they consider to be relevant to their engagement with their prosecution. So we think that's very helpful, simplifying, clarifying language to put in this definition, that non-compliance with court orders should be considered in the risk analysis. We think that's very important. And we think that there is often a real emphasis on failures to appear. But just to pause for a second, if someone has failed to appear, we've not mitigated the risk of flight. They have already flown. And so looking at non-compliance in that analysis, we think is important. And certainly it's an individual analysis. I know you had an actual individual in Bennington County that was flying an airplane that made the news down there. So the real risk of flight. But we do think that this definition is supported by certainly our executive committee and our department, the definition change that you've put in here. Yeah,
So just to a point earlier that I had raised, and I think I must have phrased it the wrong way. So non-compliance alone doesn't rise to the level where it can be used to determine a flight from prosecution. There has to be other factors, but the non-compliance is one of multiple factors.
Yeah, it's one of multiple factors. And the other thing is what this bill, we talked a little bit about. 7554 is about imposition of bail or not, imposition of conditions or not. 7575 is about revoking the access to bail. So that's a different topic in that context over there. State v. Save, the court found that violations of conditions of release on their own are not sufficient to be a per se reason to have someone's constitutional right of access to bail. Bail historically is the key out of the detention center. And so when we're thinking about these issues, think about 75 over here, that's revocation, 7554 over here, that's about the analysis for imposition. The analysis for imposition of bail, you should absolutely be considering whether or not someone's complying with their court orders. It appears incredibly relevant to whether or not they're going to engage with their own prosecution. So there's two separate topics that were discussed during the hearing today, and they're sort of distinct, but the bail analysis, we think conditions of release should be part of the analysis. It sounds like you're striking the diversion pieces about repeat offenders. I'll move on. Last point, don't take a position about the new staff for DOC, other than to note that if there is going to be supervision in a more direct manner, it certainly could help with compliance, and it'll be interesting to see how it plays out. It could result in a downturn of VCRs, but it could also result in those supervising entities calling the police saying, I have no idea where this person is, but I think they're at the victim's house. And then you get a VCR filing, which could have an impact on the limited court time. And so we're very much in favor of the discussions you've already had in this committee on expanding the opportunities to litigate and bring to trial or have trial dates for misdemeanors, because it will help resolve those cases. And that's really that's all I had.
Thank you. Thank you for the Senator Sheen has.
Just a quick question regarding S-196, and just for the committee, that was the bill related to rules of evidence and the 7553A hearings. Do you have any opinion on whether we can add that to S-195 or the miscellaneous judiciary bill? I think I brought that up. That was the one I brought up over the weekend.
Well, just keeping in mind that it's for the purposes of anyone listening, but also yourselves, they're different topics. Yeah. Obviously, hold without bail is about those very small circumstances where there's in the Constitution, someone could be held without bail. Certainly a policy call, just noting that it's a very different topic. There's some benefits to keeping it separate because it's such a discrete topic area, but in the whole universe of bail, hold without bail, conditions, maybe there's some germaneness there. I leave it to legislative council and your own judgment on that.
Thanks.
We're in support of S-196, as you know.
So hopefully, Ben appears to give you a whole week to work on some of the comments, and maybe you and I can discuss along with other committee members what we've heard today from the various parties, and got to work that out. So if you've got some time for you and I to meet along with Senator Sheen, the vice chair, and talk about what we'd like to add, subtract, and how we look at a different version. And we can do it on Zoom if you're not feeling up to it.
Well, I hope to be back in the office tomorrow, so I will make time.
We haven't seen you yet, so we don't know if we want.
Well, one way or the other, we'll meet, and I'll be ready and willing.
Thank you. Tim, I appreciate the comments and concerns. We spent a lot of time this year talking about drug crimes. We haven't spent much time talking about domestic violence and its impact on the system. But I think that when I think about home detention and electronic monitoring, I think about domestic violence. In cases where the victim is amenable to those alternatives. The record from Windham County when they were doing it was pretty good. And there's a lot of success. And so I hope that rather than, I understand this puts pressure on the Department of Corrections, but I think there's a lot of hope. And rather than using jail really for those who commit domestic violence, we have alternatives that both protect the victim but also allow the defendant to maintain a job, pay taxes, pay child support, and whatever else. I hope you have some ideas on how that might work better. While Sheriff Clark is no longer in the position of sheriff in the county, Sheriff Anderson was interested and provided me with a copy of the report that was done a few years ago on the success of that program. So I just really strongly maybe goes along to some of what Ben was saying, Jay was saying, as I was being the old cantankerous guy. If we don't have alternatives to incarceration, then we have two choices. Put somebody in jail or leave them in the community unsupervised without maybe the means to make changes in their lives. That's what's really important. And the longer somebody who's left out there on their own, the more likely they are to have violations of conditions because life goes on. So that's really the goal here.
One piece I
necessarily put more people in jail, but I understand where it's.
One piece I included in testimony earlier this year, and I resubmitted it today, was I took some pullouts from the Illinois law about violations of conditions of release. That it's a pretty new law, but for your reference, and it's on your committee website about what happens when someone violates in their new scheme of presumptive no bail in Illinois, and I found it to be an interesting look in that it does provide some accountability measures that Vermont is currently lacking in terms of the violations.
Senator Hosky.
I have a quick question. I actually think it's for Commissioner Demmel though, and it's about pretrial notifications and where we are on some, or maybe it's for the judiciary. I don't even know who the question is for, but haven't we talked in the past about
Text messages?
yes, where are we at in that process? Is that a question? No, it's not, because you don't do pretrial yet.
Yeah.
Do you know, Tim?
So I've heard, I'll let Matt Valerio talk about this more, but I've heard that I believe they were working on something where they would have text messages. The issue in Vermont is connectivity and access to cellular reliability. Yeah.
They might know.
Yeah, that's just really helpful. I know the Chicago Crime Lab showed a 26% decrease in failure to appear by implementing a combination text system. So I think and actually changing their court summons. So I think there's some low-lying fruit here to get us to where we are not putting more people in jail and we're not rolling back policy meant to keep people out of jail.
Well, my Discover card can send me an immediate text that I charged something over $50 while I'm standing there for the court to hand me back the card. I guess we could do that.
Yeah.
But I don't know how much it costs Discover to do that. But.
Well, I imagine they probably have a lot more money than the state of Vermont, but given that they're a multinational corporation.
I have no idea who they are, but they send me text messages. All right.